One of the problems here is that there is so little case law on the Insurrection Act because this is not normal. People, I know we say that a lot. And think about it. The course of our nation's history, we've had wars, we've had all kinds of things with protest has been an inherent part of our democratic system since the beginning. We are celebrating 250 years of a protest that led to independence. So this is such a natural and crucial part of our society, and it always has been since the nation's founding. The idea that protests amount to something that would give the president the power to invoke the Insurrection Act just seems to defy common sense. But what we do know is that the Supreme Court did, back in 1827, rule that invoking the Insurrection Act is a power that rests exclusively with the presidency. So we've talked about other powers that the president has that's not reviewable. The clearest example is the pardon power. If the president pardons somebody, nobody can appeal that. The courts can't come in and say, no, you can't pardon that person. That's a power that rests with the presidency. And in a case called Martin v. Mott, the court said that invoking the Insurrection Act, too, is up to the president and that it is his exclusive domain. Now, there has been at least one other case, one called Sterling v. Constantine, which said, well, okay, yes, this is a right that rests exclusively with the president, but there are, as explained in this act, limits to it. There are criteria in there. And in determining whether or not the underlying conditions are legal to qualify for this, of course, courts have the ability to come in and determine that. If you don't, then you're just handing the president a blank check to call the military into cities at any time. And that's not what this really is.